Well, welcome and welcome back, everyone, to the fourth meeting of the Social Contract Research Network Zoom seminar for this semester. It is my delight to introduce our speaker for the evening. Douglas Guilfoyle is Professor of Law in the School of Humanities and Social Sciences at the University of New South Wales. He's an expert in maritime security and the international law of the sea. And he leads research on naval law enforcement, international tribunals, and the historical development of maritime legal regimes. He's currently also, I think, still an ARC Future Fellow. And his fellowship project examines how small states use international legal mechanisms to challenge more powerful nations, very interestingly, reflecting his broader interest in the oceans as a global commons and the evolving legal frameworks that govern them. He's also, it's worth noting, the co-host of the very fascinating podcast Called to the Bar, with a telling subtitle, International Law Over Drinks, which is well worth a listen, both for lawyers and for non-lawyers alike. And given that the theme of these seminars this semester is the commons and the common good, I'm particularly excited that Doug has agreed to speak today on the theme, the oceans as a commons, everyone's, no one's, or the public good. So would you please join me in welcoming our speaker for this session, Professor Douglas Guilfoyle.
Everyone, and thank you, Chris, for that very kind introduction. I'm presuming an audience of non-lawyers this evening, and I'm attempting to engage with the issue of the oceans as a commons from a number of directions. So I'll be introducing some legal concepts. I'll be introducing some history to do with the politics of the framing of the UN Convention on the Law of the Sea, and talking a bit about how it divides maritime space. Then I'll turn to some of the critiques of the regime that we have, including from a maritime security perspective, and also from theoretical perspectives, including feminist, post-human, and queer perspectives on the law of the sea. And then I'll try and wrap that together. So I have a few slides. They're mostly to keep me on track more than anything else. Chris, could those be shared now?
Let me see. Can I share on your behalf?
I thought sharing had been disabled and I needed to do it.
Oh, no, I think I just stopped you sharing earlier.
Okay.
But I don't think I can.
No, I can fix this, I think. I think. Does that work?
Yes, that's perfect.
Yes, that's good.
Great. Okay, good. So, so at the outset, I think I should note that not all of the oceans can be classed legally as a commons. So obviously, if we envisage ourselves standing on the shore and looking out, the first thing we see will obviously be a single expanse of water stretching to the horizon. And that expanse of sea will belong entirely to the coastal state whose shore we're standing on. So that 5 kilometers or so that we can see with the naked eye will be part of the 12 nautical mile territorial sea and will fall exclusively within that coastal state's jurisdiction. And then beyond that, beyond the visible horizon, will lie the coastal state's exclusive economic zone, or EEZ, a concept I'll come back to. But the high seas, those areas of the ocean beyond the jurisdiction of any single state, remain among the few spaces in global governance that retain something of a truly communal character. The other spaces talked about in similar terms are usually Antarctica and outer space. But this characterization, which we can shorthand as a global commons, is at the same time legally layered, theoretically contested, and politically charged. And indeed, talking of the high seas as a global commons perhaps does more to conceal than reveal the realities of power and the regimes of extraction that shape contemporary ocean governance. The very notion of a commons, historically tied to collective management, equitable access, and non-exclusivity, is under strain in a number of ways in ocean space. So the idea of the high seas as a commons reflects a layered legal imaginary, one shaped by centuries of maritime custom, codified in treaties such as the United Nations Convention on the Law of the Sea, or UNCLOS, that I'll refer to a lot, but one increasingly pressed upon by the practical and normative demands of environmental protection, technological development, and increasingly geopolitical rivalry. So in this talk, I'm going to attempt to consider the high seas as I've foreshadowed expansively, not merely as a zone of freedom or a resource frontier, but as a legal construct that represents the legacy of or the embodiment of debates about global power, equity, and shared responsibility. That is, if the high seas are a commons, we should be asking ourselves, common to who, for what purposes, and under what conditions of access and control. So to do this, I need to both outline and then interrogate some of the legal categories that underline the high seas regime. Now, these are obviously not only legal or environmental questions, but also political ones tied to histories of inclusion or exclusion, patterns of extraction, and ongoing projects to attempt to decolonize international law. But oceans governance isn't just a question of ideas. The nature of the ocean itself presents governance challenges that are fundamentally different from those that we encounter on land. The very materiality of the ocean resists fixity. There are no natural borders we can find, few permanent features to demarcate zones, and no stationary populations to anchor jurisdictional claims. Enforcement, too, is complicated by vast distances, overlapping legal authorities, and limited surveillance capacity. As a result, even widely accepted rules, such as those governing illegal, unreported, and unregulated fishing, sometimes called IUU fishing, will often lack anything approaching robust compliance mechanisms. And I'll come back to some of the challenges of the lack of regulation in the fisheries sector. But moreover, the ocean's fluidity and interconnectedness renders it a medium for transboundary harm. Plastics discarded at one coastline wash ashore thousands of kilometres away. Ocean acidification, a function of global carbon emissions, degrades ecosystems in ways no single state can mitigate alone. The migratory nature of marine species, coupled with shifting currents and also temperature patterns in the ocean, make conservation efforts particularly difficult to coordinate and their benefits challenging to equitably distribute. So legal regimes have over time proliferated in response to the challenge of the oceans, not just the UN Convention on the Law of the Sea, but also a body established by it, the International Seabed Authority, that I'll have a lot to say about in an historical context. Also, the International Maritime Organization that predates UNCLOS and is in some ways both one of the more effective UN regulatory arms, but also limited by the basic lack of enforcement capacities of international law. It's essentially a standard-setting body that governs treaties to do with ship safety, ship crewing, and the prevention of pollution and other associated matters. Another important instrument that I'll come back to is the recently adopted Agreement on Biodiversity in Areas Beyond National Jurisdiction, or the BBNJ agreement. But beyond that, there is a mosaic of regional fisheries and environmental instruments. But this very proliferation gives rise to problems of fragmentation and coordination. Different regimes adopt different logics, apply to different actors, and often lack effective mechanisms for coordination, or as I've foreshadowed, enforcement. So how do we develop norms and structures capable of governing a medium that is mobile, interconnected, and shaped by forces that escape human control? What kind of legal reasoning can adequately account for the ocean's dynamism and multiplicity, while resisting the re-imposition of state-based territorial logics? These aren't questions just of strict black letter law in the sense of what is the rule and how do we apply it, but of a legal worldview? What approach do we take to these questions? What different approaches might we need to take to the law of the sea to find the possibility of a truly just ocean commons? Now, I'm going to start stepping through some of these ideas, but I should note that at the outset, I owe particular debts here to the work of Gemma Andrione and Gina Heathcote, above and beyond some of the scholars I'll refer to expressly. All right, so against that backdrop, it's relevant to think about or to introduce a number of legal concepts and categories that are relevant when we think about the law of the sea. So the high seas hold a special place in international law because they're one of the few areas where no country can claim sovereignty. This makes them distinctive in a legal system that is otherwise based on territorial control by states. Their status is both unusual and important. While no state owns them, all states have a stake in how they are used and managed. In governing the high seas and other ocean spaces, the international law of the sea operates in sort of two basic modes or registers. It orders space and it regulates activities. So these are normally referred to as the zonal and functional approaches to the law of the sea. And the law of the sea does so, usually navigating between competing principles of, on the one hand, freedom, and on the other hand, sovereign jurisdiction or control. Now, that frontier between control and freedom has shifted over time, representing a balance of rights and interests in the uses of the ocean. But the heart of that story of legal development is the line between the territorial sea, and its very name, when you think about it, is an oxymoron, right? You know, the territorial sea, representing sovereign control by the adjacent state based on its control over the land, and the high seas, which represents freedom. And interestingly, the term high seas is, I think, a translation of the legal French haute mer, which in its original context probably meant more deep sea than high sea. In any event, as I shall come back to, that line between sovereignty and freedom has become increasingly complex or even overlapping in terms of the creation of new legal categories. Now, thinking, though, of the high seas as a common, any commons governed only by a principle of freedom, if that's what's left after sovereignty and control, has a number of obvious problems. Harden's classic 1968 article, The Tragedy of the Commons, while it rested on an historically and anthropologically inaccurate depiction of the role of commons that has been widely debunked, was unfortunately quite accurate in its predictions in relation to the management of the high seas. For the large part, at least in relation to global fish stocks, he was right to say that freedom in a commons can bring ruin to all. All right, but returning to the principle of freedom, the idea that there should be an area beyond state control that is free and open to all goes back to the concept of, as I've got it on the slide, mare liberum, the free sea, made famous by the jurist Hugo Grotius in the early 17th century. Now, Grotius argued, as a matter of logic and the laws of nature, that the sea should belong to no one because it was too vast to be owned and is naturally suited for shared use. He also had some rather optimistic views about the inexhaustibility of the resources of the sea. But his vision supported open access for trade, fishing, and naval movement, a principle that served the interests of maritime powers at the time and still shapes legal thinking today. Indeed, the Grotian conception arose from an expressly political struggle. He wrote during a time of rising maritime conflict, particularly between England and the Dutch Republic, and against the backdrop of increasing competition for fishing rights and trade routes. His great academic rival was the English writer John Selden, who promoted a vision of mare clausum and sovereign control over stretches of oceans, or at least adjacent oceans to a coastline, an idea now associated with the law of the territorial sea. So these ideas are, in some sense, still with us in this competition between territorial control and the open high seas. In any event, The legal consequences of a principle of freedom, saying that the high seas are free and open to all, are not self-evident or straightforward. Grotius observed that the high seas had variously been characterized as res nullius, belonging to no one, res communis, common property, or res publica, public property or a public good. So here in the title of my presentation are the high seas everyone's, no one's, or a public good. The problem is choosing amongst these doesn't actually resolve any question for us, in that these terms express less precise legal concepts and an associated package of rules than what the great writer in The Law of the Sea, D.P. O'Connell, called attitudes of mind. That is, the predisposition we bring to questions of governance. What rules should there be? And then also the question of how we interpret those rules. So each of these different approaches, common property, public property, it belongs to no one, implies a different perspective. One might view freedom from sovereignty claims positively, that is, as a feature of a world public order that results in a common space inherently regulated by law. Or alternatively, one could view it negatively, that it establishes a minimally regulated space where states may only act if authorized by international law. Or conversely, and unfortunately perhaps the more prevalent view, as a space in which everything is permitted, which is not prohibited. Now, from my point of view as a what's called a doctrinal lawyer, someone who is interested in the nature and content of specific rules, it's important to say that the high seas are not a lawless zone or a legal vacuum. While the high seas is beyond the logic of territoriality, it is not beyond the legal logics of nationality and universality. Now, what do I mean by that? So ships at sea are treated as having the nationality of their flag state, and their flag state is in turn responsible for their compliance with relevant and applicable laws, and those ships are subject to their flag state's jurisdiction. So this is how we provide for order on the high seas. Ships are not floating pieces of territory, but they are jurisdictional objects tied to a state which has the authority and responsibility to regulate them. In a limited range of cases, principally the repression of piracy, the law of the sea also provides certain universal rights of enforcement against delinquent vessels, absent those ties of nationality. Now, from these basic principles, the relevant law has grown denser over time, but the key constitution for the oceans is now usually taken to be, as I've foreshadowed, the UN Convention on the Law of the Sea, or UNCLOS. UNCLOS defines the high seas negatively, that is, as comprising all parts of the sea that are not included in the exclusive economic zone, in the territorial sea, or in the internal waters of a state. Now, I'll come back to the significance of the exclusive economic zone, or EEZ, as a site of struggle. But under UNCLOS, the high seas are, or are supposed to be, subject to a set of rules that balance freedoms with responsibilities. UNCLOS recognises several key freedoms, including navigation, overflight, the right to lay submarine cables, freedom of fishing and scientific research, but none of these rights are absolute. Rather, they are subject to qualification by other rules of law, as any freedom exercised in the interest of all must be regulated to safeguard its exercise for the benefit of the entire international community. What is less often acknowledged is that these freedoms reflect not some universalist ideal or outgrowth of natural law reasoning, but an historically contingent balance of interests that was structured during the negotiation of the UN Convention on the Law of the Sea in a 1970s contest between dominant maritime powers and an increasingly assertive, but also diverse, post-decolonization global South, which was keen to reshape the international legal order to reflect its own interests. So this brings me to my next theme in the presentation, the negotiation of UNCLOS. All right, the history of modern oceans governance traces back, and this will feel like a digression, in part to the discovery of polymetallic or manganese nodules on the deep seabed. These nodules, first identified at depths of enormous depths of 4,000 to 5,000 meters, were discovered to contain potentially commercially valuable minerals like nickel, copper, and cobalt in significant quantities. Now, as a sidebar, that fact has become more important potentially important in terms of a global transition to renewable energy and the need for these minerals in technologies like batteries. In any event, interest in seabed mining increased significantly in the 1950s, with commercially valuable deposits discovered near Tahiti in 1957, 1958. Improvements in mining technology made these deposits appear potentially commercially exploitable at some point in the near future. But as I joke to students, we're now about 80 years into a continuing sort of horizon of deep sea mining being 10 years away technologically. That is, on any given day in that 80 years, you would have found someone who said, oh, it's coming soon. It will be here within the decade. In any event, commercial actors began pursuing seabed mining by the 1970s. And one particular early actor in the United States, Deep Sea Ventures, sought US diplomatic protection for its claims in areas beyond national jurisdiction based merely on prospecting. That is, they wanted the United States to assert to the rest of the world that only Deep Sea Ventures could mine in this identified area in what's now called the Clarion-Clipperton Zone. The US government's position at the time was that mining beyond national jurisdiction could proceed as a freedom of the high seas, but there was no basis on which the US could recognize or confer exclusive title to a mining site. And there are reasons that that view may have changed now under the Trump administration. In any event, the question then arises as to how such mining might be governed. The first place you'd look in the 1950s would be the Geneva Conventions on the Law of the Sea. They did not provide much of an answer, and I'll try and explain why. So the four Geneva Conventions on the Law of the Sea of 1958 were landmark events, but fell short of creating a universal legal regime. First, they didn't settle the major outstanding question of the law of the sea, which was the width of the territorial sea. You can't tell where the high sea begins unless you know where other zones under sovereign jurisdiction end. And indeed, a second UN conference called in 1960 failed to address or failed to reach resolution on the territorial sea issue, despite it being the only question they were called to consider. Second, the draft treaty text for a single law of the sea, prepared by the United Nations International Law Commission, was in 1958 split into four conventions, covering respectively the territorial sea and contiguous zone, a convention on the high seas, the convention on fishing and the conservation of living resources of the high seas, and the convention on the continental shelf. But breaking the law into four separate conventions in 1958 allowed states to pick and choose which parts of the law they would adhere to, that they would sign up to, resulting in varying levels of ratification and an unsatisfactory framework for oceans governance. Further, nothing in the 58 conventions directly addressed mining beyond the limits of the continental shelf. At best, such activity might be legal, but effectively unregulated under the general principle of freedom of the high seas, a result that was unsatisfactory from a number of perspectives, but including that of commercial actors who would want security of title before they began exploiting valuable areas of the ocean floor. The exploitation of natural resources of the deep seabed beyond national jurisdiction was first placed on the UN agenda by the Maltese ambassador, Dr. Arvid Pardo, in 1967, calling for these resources to be managed as the common heritage of all mankind in a speech to the UN General Assembly. Pardo feared a scramble for seabed resources under the existing freedom of the high seas and felt that such a result would advantage developed states over less developed ones. These concerns also arose during the process of decolonization across the 1950s and 1960s and the rise of New International Economic Order, or NIEO, stream of thought among newly independent states. That is, many in the developing world saw the potential race for resources of the deep seabeds as a maritime repeat of the scramble for Africa in the late 19th and early 20th century. So there was widespread dissatisfaction with traditional rules which were seen to privilege technologically capable states, and this led to pressures for a new regime. Newly independent states in particular sought more control over resources adjacent to their coasts and began asserting substantial maritime zones, such as the Latin American concept of the 200 nautical mile patrimonial sea. There was also increasing concern about marine environmental protection following the Torrey Canyon oil spill in 1967. So while polymetallic nodules had been theoretically known of since the late 19th century, obviously they were rediscovered as a potentially commercially exploitable resource in the late 1950s and early 1960s. And this ultimately served as the catalyst to reopen the question of the codification of the law of the sea, and could there be a single treaty to govern it? Now, admittedly, while all this was driven by prospects of seabed mining, some of the projections as to the scale of resources available and the ease of their exploitation were in fact wildly optimistic. And much of the debate was driven by a single book by a man called John Mayrow, who did take quite optimistic views as to what might happen. In any event, as a consequence of Pardoe's intervention, the UN General Assembly established first a seabed committee in 1967 to examine questions related to deep seabed resource exploitation beyond national jurisdiction. Newly independent states sought to internationalize these resources under Pardoe's label of the common heritage of mankind to prevent developed states from dominating their exploitation. But once the possibility of revising oceans law was opened, various national groupings saw opportunities to advance their own claims, such as South American states advocating for wider coastal state authority out to 200 nautical miles, as I've mentioned. Major powers like the US and USSR also wanted certainty around a 12 nautical mile territorial sea, coupled with a new system of international straits passage that would preserve high seas corridors for naval mobility. Fundamentally, though, establishing any rules for the seabed beyond national jurisdiction required settling the limits of national jurisdiction, especially the continental shelf, which the 1958 convention had defined unsatisfactorily. Essentially, it hadn't given a stable criterion for where the continental shelf that appertained to the coast of a state would end. So growing concerns about overfishing and marine pollution were also significant. Now, the interconnectedness of these issues led to an agreement to convene a new General Conference on the Law of the Sea to draw up a new unified treaty on the law of the sea. Now, the complexity of these negotiations is underlined by the fact that they spanned nearly a decade, the years from 1973 to 1982 in annual meetings each year. Even more unusually, the conference began in 1973 without a draft negotiating text. Instead, states brought with them a vast mass of conflicting proposals. And this was partly due to newly independent developing states' suspicion of how previous texts had been assembled in the UN system, and particularly by the International Law Commission. Further, too many states saw vital issues of national interest here and thought everything should be negotiated by political representatives rather than in advance by lawyers. Across the near decade, negotiations in any round, any session involved around 140 states, plus numerous non-state actors, although the most effective non-state actors were from the mining industry. Two guiding principles emerged in this negotiation, and I promise these are relevant. The first was the gentleman's agreement, emphasizing that decisions on advancing the text would be taken by consensus. And the second was the idea of the package deal, stipulating that the final convention would be an integral unit with no reservations. That is, generally speaking, because international law is based on consent, states may enter a reservation to a treaty and say they do not agree to be bound by certain provisions. But the idea of UNCLOS was to be that it would be take it or leave it. You had to sign up to all of it or none of it, and could only use any opt-outs that were expressly provided for. So the package deal process, negotiated by consensus, aimed to meet the minimum interests of the largest majority while accommodating the essential interests of major powers and dominant interest groups. Necessarily, this involved trade-offs. For example, the Group of 77 less developed states guaranteeing the navigational freedoms of major powers in exchange for their recognizing sovereign rights over exclusive economic zone resources. So it resulted in what has often been described as an intricately interlocking web of compromises. Now, the negotiating dynamic, while this was in some ways at the height of the Cold War, rapidly shifted from East-West Cold War tensions towards a North-South confrontation, with developed states sharing common interests in freedom of navigation and potentially seabed mining, while the group of 77 developing states held common views on seabed mining, but lacked unity on many other issues. That said, some questions, such as the new EEZ regime and special rules for archipelagic states, became totemic developing world issues and were backed by most of the group of 77, even if they were not of immediate benefit to all members. So states formed fluid, temporary, and overlapping interest groups based on shared interests. In any event, the conclusion of UNCLOS resulted in substantial changes and additions to the law of the sea. First, resolving a long-standing dispute, acceptance of a 12 nautical mile territorial sea. Second, introduction of the concept of archipelagic waters, which I won't touch on too much, but a special regime for the internal waters of mid-ocean archipelagic states like Fiji, Indonesia, and the Philippines. A very complex formula and system was implemented for determining the vexed limits of national continental shelf entitlements, but this was a vital first step in determining what would be left over as the common heritage of mankind beyond national jurisdiction. An acceptance of the 200 nautical mile exclusive economic zone concept for coastal states, balancing the interests of what was sometimes called the geologically disinherited states, those states lacking a natural extended continental shelf, seeking resource control, but also balancing that with maritime powers' desire to preserve freedom of navigation. So this EEZ concept, as I've said, emerged from the Latin American patrimonial sea and African exclusive economic zones. And it was characterized to balance these competing interests as a sui generis zone, neither the high seas nor the territorial sea. The EEZ concept was rapidly and very widely accepted and is generally considered to have become part of customary international law even before UNCLOS's entry into force. However, while intended to redistribute wealth, the EEZ has primarily benefited coastal states, particularly developed ones with long coastlines and rich fishing grounds. On that note, UNCLOS also made provisions for fisheries conservation, including broad outlines of a management regime within the new exclusive economic zone, and cooperation regarding straddling and highly migratory stocks. That is, with the projection of the EEZ further into the high seas, fish don't read maps, and a biomass of fish might be found to overlap an area of one state's EEZ and the high seas, or to be migratory and move between EEZs and the high seas. So special provisions were made about how such stocks should be managed, and those very general duties were later given more detail in a subsequent agreement, the Fish Stocks Agreement. UNCLOS also included an innovative compulsory dispute settlement body and established the International Tribunal of the Sea, which I'll return to for present purposes. The UNCLOS established a regime for deep seabed mining in the area beyond national jurisdiction, which was to be conducted, and sorry, that area beyond national jurisdiction is shorthanded as the capital A area, under the supervision of an international seabed authority. Now, this was a highly controversial exercise. Developed states wanted a minimal ISA acting largely as a registry of title claims, while the group of 77 wanted an ISA with not only extensive regulatory powers, but that would act as the sole legal mining enterprise. A so-called parallel system compromise was eventually adopted, allowing both commercial mining and mining by an ISA enterprise, not the Starship, a legal body, but with some advantages built in for the enterprise. That is, it would get specially reserved sites and could benefit from technology transfer from developed states. So developed states had significant concerns about the ISA's cost effectiveness, its seeming lack of market orientation, in that it encompassed mechanisms such as production limits, which were more familiar to planned economies, and its decision-making process, which would be by majority and therefore potentially, as it were, lock developed states out of decision-making if developing states were the majority. So a major crisis in all of this occurred with the election of US President Ronald Reagan in 1981 before the treaty was concluded. The Reagan administration found the draft treaty, especially the seabed mining provisions and new international economic order ideas, objectionable. The position was obviously ideological, influenced by the mining industry and free market think tanks. Some in the administration wanted to walk away from the treaty entirely, viewing it as setting bad precedents for North-South negotiations and subjecting US industry to international control. Others felt the treaty was improvable and necessary if there were to be any legally stable regime supporting seabed mining. In event, the US, because it was so late in the day, ultimately failed to secure substantive changes. And the final text of the convention was adopted by a vote in April 1982, 130 in favour, 4 against, and 17 abstentions. But the notable thing in the context of seabed mining was the abstentions and objections tended to come from the states that looked like they would have the technology, the developed states, to conduct seabed mining. So how is seabed mining going to occur if they weren't willing to sign up to the convention? So this led to a crisis as the convention was on the point of entering force in the early 1990s, in 1994. Ultimately, if industrialized states with mining capacity did not participate, large parts of the convention could be rendered ineffective, especially the mining regime and the new institutions, the International Seabed Authority and the International Tribunal for the Law of the Sea, which would require funding. So to address developed states' concerns, in 1994, an implementing agreement was brokered. This, in effect, altered the proposed seabed mining regime to address developed states' concerns on questions such as cost effectiveness, technology transfer, market-oriented approach, the role of the enterprise, and essentially ended majority decision-making in the ISA. These changes resulted in a radical rewriting of the deep seabed mining regime. So broadly, we could say that in the 1990s, as the price of their joining UNCLOS, highly industrialized states succeeded in forcing the rewriting of the Group of 77's preferred rules for the ISA regime, making it friendlier to corporate exploitation of the deep seabed and less an instrument of a planned economy for the common heritage of mankind. All right. Perhaps quite a lot on that. Let me move on to what the division of ocean space looks like under UNCLOS. So UNCLOS set up this complex system of jurisdiction. And arguably, despite all of this talk about the deep seabed, the area beyond national jurisdiction, the common heritage of mankind, the primary result of UNCLOS was perhaps, in fact, the radical diminution of the area that could be considered a commons. So most significant to the spatial order that was established was the emergence of the exclusive economic zone, as I've foreshadowed. So where once sovereign control ended at the limits of the territorial sea, coastal states after UNCLOS have sovereign rights to natural resources in a 200 nautical mile EEZ, extending their economic jurisdiction and certain sovereign rights over economic activities, though not their full sovereignty, far beyond traditional limits. And as noted, this was in part a response to decolonisation. Coastal states, particularly in the global south, sought to secure rights over offshore fisheries and seabed resources. And part of this was a resistance to what was seen as the maritime hegemony of developed states with distant water fishing fleets. These were often seen as plundering the adjacent waters of developing states. But the emergence of such zones was initially resisted by major maritime powers, fearing the impact on freedom of navigation. So the EEZ, as it was established, represents a compromise. It extends national regulatory power for economic purposes while maintaining high seas freedoms in other respects, such as navigation. It's not an extension of the territorial sea. Rather, it is a zone in which the coastal state has certain rights, but in which the high seas regime continues to apply to the extent it's not compatible with those rights. The result, as Maria Gavunelli has noted, is that the EEZ remains to this day conceptually ambiguous, neither a fully sovereign space nor fully international, and still, in respect of certain key environmental and navigational obligations, is dependent on flag state rather than coastal state control. Further, we can see in this distinction established where the international seabed has a regulatory regime for the sea floor, there is no such uniform regulatory regime for the water column above it, the high seas. So the result is a stratified oceanic legal order, one in which functional zones, the territorial sea, the EEZ, the high seas, the area, interact but do not cohere around a single vision of the commons. Now, one question is whether that has changed somewhat with the emergence of interest in biodiversity beyond national jurisdiction. I'll limit my remarks under this head, but essentially the concern became that deep seabed mining had been addressed as if all that was on the seafloor were resources to be picked up. And instead, we now know, particularly around hydrothermal vents, there are enormous clusters of very unique forms of life. So this has led to the emerging field of marine bioprospecting and the necessity of the agreement under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, the BBNJ agreement. So it seeks to address this newly identified gap that there's nothing in place that protects or regulates the exploitation of living resources on the deep sea floor. Now, I don't have time to address the complex institutional legal architecture that this new agreement seeks to erect, but broadly it proposes new mechanisms for marine protected areas, environmental impact assessments, and capacity building for developing states. Importantly, it does so without altering the underlying jurisdictional framework of UNCLOS, which raises some questions about how the norms and rules it generates will interact with things like the International Seabed Authority. The BBNJ negotiation also exposed geopolitical divides. Developing states once again expressed concerns about benefit sharing, especially regarding genetic resources that might be exploited commercially. Also, traditional maritime powers were suspicious of regulatory overreach. Thus, it might be said that while concluding any agreement at all on this topic represented a very significant achievement, a multilateral treaty of this scale has not been negotiated in some years. Nonetheless, it appears to replay a number of the issues and tensions present in the UNCLOS negotiations. Nonetheless, it does put the idea of environmental stewardship front and center in a way that perhaps the traditional law of the sea has not. Before closing for discussion, there are a couple of other issues I'd like to touch on briefly. One is the increasing logic of the securitization of the oceans. So contemporary maritime security discourse, a significant field of my own research, has evolved well beyond conventional hard power questions of naval strategy and maritime boundaries. So increasingly, the sea is seen as a theatre for hybrid and non-traditional threats, cyber intrusions into port infrastructure, the vulnerability of the undersea cables that carry more than 95% of global data, and the securitization of maritime migration routes. Each of these raises difficult questions about jurisdiction, attribution, and the adequacy of existing legal frameworks to deal with 21st century challenges. In particular, I'd note in passing the work of the journalist Ian Urbina. His book Outlaw Ocean, in particular, paints a picture of an often unregulated and chaotic human environment rife with exploitation and abuse. And his work depicts the sea as easily becoming a prison to those working or traveling upon it. For example, sailors can often be forced to work inhuman hours for little pay, often in dangerous and unhealthy conditions. And beyond the dangers of the ocean itself, maritime workers often face violence, including sexual violence, from ship's captains and officers. His work also deals with modern slavery at sea, presenting distressing stories like that of a fisherman shackled by the neck and sold between deep sea fishing vessels that seldom called at port. And many of these exploited sailors come from impoverished communities in developing countries, making them easy targets. In all of this, Urbina sees a system of a lot of law and little enforcement, one that perhaps provides, in some ways, great thickets of law in which bad actors may hide. There's more I could say on this point, but I'll pass over it because there's perhaps a more optimistic account I want to get to, at least quickly. So this brings me to other ways of seeing the oceans as a commons, in conclusion, grounded in critical approaches to international law. So feminist, queer, and post-human legal scholarship invites us to reimagine the high seas, not just as a legal category, but as a site of ontological and epistemological complexity. These approaches challenge dominant logics that have long shaped ocean governance, rationalities rooted in territory, extraction, hierarchical distinctions between human and non-human, subject and object, land and sea. And in doing so, they open up alternative ways of understanding the high seas as commons, not merely as a resource space, but as a relational and political domain that unsettles sovereign modes of knowing and controlling. Post-human feminist scholarship questions the juridical and scientific binaries that underpin the law of the sea. The sea in this reading is not a neutral backdrop to human action, but a dynamic actor in its own right, fluid, resistant to enclosure, and generative of alternative temporalities and spatialities. Gina Heathcote's work in particular suggests that oceans governance cannot be fully understood without accounting for the gendered and racialized logics embedded in global security and development regimes, logics that often render maritime spaces as sites of both economic opportunity and strategic threat. Heathcote in particular sees the oceans as an unruly commons and a legal subject in its own right. Queer theory, with its emphasis on norm disruption, is similarly instructive. The high seas, after all, are legally and metaphorically queer spaces, zones where the normative orders of sovereignty, citizenship, and territorial jurisdiction are suspended or transformed, where governments must contest with uncertainty, mobility, and interdependence. Queer approaches invite us to think with the ocean's indeterminacy rather than against it, to resist the impulse to fix or contain, and try instead to cultivate an ethic of openness, care, and relationality. So such perspectives are not just abstract critiques. They have an implication for legal design and institutional imagination. They put us to question what kind of actors count in ocean lawmaking, what forms of knowledge are recognized, and what futures are made possible or foreclosed. They direct our attention to silences in the law, the invisibility of small island voices in deep seabed governance, the marginalization of traditional and indigenous oceanic ways of knowing, and the reductive treatment of marine life as resources rather than as legal subjects. In rethinking the high seas as a common, these lenses offer more than a critique. They invite us towards methods of care, relationality, and responsibility that might underwrite a different and perhaps more just and sustainable oceans governance regime. They challenge us to imagine the law not only as a set of rules, but a collective practice, one that responds not merely to geopolitical power, but also to the entangled needs of our planetary community. There are other things I could say in conclusion, including as to how small island states have used some of the institutions established under the Law of the Sea Convention, such as the International Tribunal for the Law of the Sea, to attempt to assert their voices, again, perhaps in a way that hasn't been seen since the 1970s. But I think in the interest of time, I've had more than my 50 minutes. And Chris, I might close my remarks there if I can find the meeting again. Thank you
Wonderful.
very much.
Well, thank you. My goodness, what a rich presentation, and one that I particularly enjoyed as someone who has no legal training whatsoever. I always find it fascinating, and I'm sure this idea will be shared by others here, how people across different disciplines don't only think about different things, but think differently about
Yes.
things. How one's mind works differently in different disciplines. It's fascinating to hear a legal mind thinking through these issues. Let me remind people who've been here before, and let people know for whom this is your first seminar, that questions and comments are very much welcome. If you would like to ask a question or make a comment, could you just put a quick note in the chat so that I know that you'd like to ask a comment, and then I will call on people in the order in which you announce yourselves in the chat to make sure that there's no sort of awkward moments of everyone trying to jump in at the same time. And while people are gathering their thoughts, I wonder if I could kick off with the first question, which will come from someone who thinks like a philosopher. So sorry if this question sort of crunches the gears of the way that you approach these things. But the ideas that you were setting out triggered off for me was the question of whether the commons, as it's understood within maritime law, is a legal fiction or not, and what that means. In other words, is the idea of the oceans as commons, so far as it exists, trying to get at some sort of ontological significance, some sort of thing that is really there, or is it simply creating something? And in the way that it understands itself, if that even makes sense as a question, is
Right.
it creating something or discovering something? And then if it is a legal fiction, how can one possibly argue for it? In contrast to, for example, someone who comes along and says, well, no, the ocean should be, every person for themselves and the devil take the hindmost. Well, how does one prosecute the case for
Right.
the oceans as commons
Right.
if it is a legal fiction?
Right. So is it discovered or is it created? And if it is merely created, how does one make the case? Okay, so reframing those categories in legal terms, we're talking about discovery or creation as it were, the difference between natural law, either God or nature has ordained these rules and they are discoverable by right reason, or a kind of what in international law, though not most other disciplines, we'd call the positivist approach, which is to say the law has been made by people and our only job is to discern it from the evidence and work out how it works in practice. Um, Ultimately, and I say this without a good grounding in philosophy, law has nothing to ground it, right?
Yeah.
You're always bootstrapping rules into existence.
Mm.
Uh, and this leads to what the great theorist Marty Koskaniemi called the problem of apology and utopia. If international law is only what states do, then you become a mere apologist. But if it is something that directs states to do things they do not wish to, then you're arguing for utopia, and there's nothing to ground those arguments. So as a sort of as a first order question, I'd always come from the positivist side and say the law is an artifact of human minds, and we impose it on an external reality. Your second question then is, how do we make the case for it if it's not grounded in something? My my semi-theoretical answer to this is the idealist international lawyer, one of a dying breed, Philip Allott at Cambridge, who you may recall, Chris, had this fabulous idea of all societies having what he called the triple constitution. So out of the British tradition, he didn't think of a constitution as a written document. He thought of it as something more abstract and ephemeral. And that triple constitution consisted of what he called the legal, the ideal, and the real. So any society has its guiding ideals, however well articulated. the real distribution of power that exists in a society, and then legal rules about how power is to be exercised. And his point that I've always kind of found very compelling was that those aren't a hierarchy, they're three corners of a triangle. And if you change the ideals of a society, for example, that might change the law, which might in turn change the real distribution of power. But if one sector of society grows overweeningly powerful, that might in turn change the law in a way that comes into conflict with the society's ideals. Or alternatively, if you change the material reality of a society, such as kind of post-World War II migration into the UK, that newly diverse population might require legal changes such as the Racial Equality Act. So that's a long way of saying the way you argue for it is eclectic, but if you choose certain ideals to guide the law, say stewardship over exploitation, if you can say we all agree on this principle, then you just start arguing about how you implement it. There might still be a lot of disagreement, but at least you've got the guiding light of the principle. And what is the guiding principle can shift from time to time, but there have been historically contingent moments when the idea of the common heritage of mankind has been very powerful, and other times where it hasn't had much traction.
Well, that's fascinating, and I would love to follow up, but I will restrain myself for the moment because I think Alan has jumped into the chat with a question, unless I'm misunderstanding your comment in the chat there, Alan.
Okay.
Oh, yep.
Hang on, I'm unmute now. No. Thanks, Douglas. That was great. I quite early on in your piece, I was thinking about the depth of the ocean, because I recall reading somewhere that in the Pacific, I think they call it the Mariana Trench. It's deeper than Mount Everest is high.
Yep.
Whereas in contrast, during the World Wars, there were a number of coastal waters where the ship would sink, and one end of it would hit the seabed with the other bit still sticking out, and you know, there are sort of famous photos of that. So I was just simply thinking, who owns a sunken ship?
Right.
And they can be sunk in so many different locations and circumstances.
So it's not, unfortunately, that's not a straightforward question. So, for example, a military vessel that sinks during an armed conflict could become protected under the law applying to war graves. But there are recent expeditions that have discovered Spanish galleons laden with treasure from the early age of exploration. There's been a debate as to whether they were at the time private vessels or government vessels. And if they were government vessels, is there chain of title from, well, there is clear chain of title from the Kingdom of Spain to the modern Kingdom of Spain. And if they're state property, they remain state property indefinitely, so long as there's not a succession or dissolution of states. So there's not one uniform regime. Where it's a commercial vessel, and this goes into questions of commercial law, I'm not an expert. My general understanding is that law incentivizes private parties to retrieve the wrecks and cargoes of commercial vessels and then gives them a share in the recovered goods. So it's sort of a commercial system where the goods still belong to the original owner, but the salvager is entitled under the law of prize to a percentage of the value recovered. But the complex case is actually the historic vessels where, you know, the real treasures are. So that's a partial answer, but I hope at the beginnings of one.
Thank you.
I wonder if I could jump in with another question at this point. It's my manganese nodules question.
Hmm.
Is there any sense and again, this may be a naive question that's framed in a way that the law simply doesn't or can't address. But is there any legal sense that the ocean possesses intrinsic value beyond its utility to humans, or that it can? Can the law think in such a way? And how does that, or how could that potentially influence our conceptualization of stewardship of the commons?
Look, and I think that's a really important question, and it's one the law is still struggling with. So, in broad terms, UNCLOS, concluded in 1982, is what's often thought of as a first-generation environmental law treaty, which has a basically extractivist philosophy, where the question is, how do you make the exploitation of nature sustainable? So it has a number of concepts in it of dubious scientific concept, like the maximum sustainable yield of a fishery. So this is the idea that there is a percentage you can harvest from a biomass on the theory that a species occupies an ecological niche, and if you pull part of that biomass out, it will grow back to fill the same space in the ecology. Ecologies don't work like that. That was the theory at the time that the treaty was negotiated. So there's been a shift increasingly in the direction of a more stewardship-oriented approach. And one of the things that's going to be interesting is essentially what I would call a normative conflict has been set up between, I'm editorializing, I don't think any of the negotiating states would say this in these terms, but between the Biological Diversity Beyond National Jurisdiction Convention and the provisions of UNCLOS that deal with seabed mining, right? Because essentially, and I heard this once from a legal officer at the International Seabed Authority. They were like, well, there's no debate to be had about whether seabed mining will occur. That debate was had in the 1970s. It's going to occur. We are the regime under which it will occur. And yes, that will have significant environmental consequences, but that decision has been made. The BBNJ treaty is essentially a separate instrument saying from an overlapping, but not completely overlapping group of states, no, we think other values are in play, but they're not merely, or they're not only preservationist values. They are also extractivist, because there is a concern about what do you do with many potentially valuable marine genetic resources. Another interesting tension that's come up is that if you look at the way the original seabed mining regime was negotiated, it was highly developed industrial states that were gung-ho for mining, and it was developing states going, no, wait a minute, there need to be some brakes put on this, largely, admittedly, more on economic than ecological bases. But now it's flipped. You have France leading the charge for an indefinite moratorium on seabed mining because of the potential ecological consequences. But you have very small states like Nauru saying, well, we want to become a sponsor of deep seabed mining companies so we get royalties because we have few other sources of income. But then within small island development, also obviously have significant communities saying, wait, it is contrary to our traditional lifestyles, livelihoods, practices, and cultural values to do this to the environment. So it cuts across a number of layers.
Thank you so much. Thank you. I think Stephanie has a question.
Hi, thank you so much for this really interesting talk. My question is actually tied, I think, to your answer to Chris's question about this idea of preservation versus extraction, and these ideas that might underlie this concept of the common heritage of humankind, because that really sort of struck me as this concept surrounding which all these debates are framed. So I just wanted to inquire a bit more about that. About what this idea of good is.
Mm.
So you touched on it just before about how there's all these shifting definitions that different parties hold in these debates. But I just wanted to ask sort of presently what the definition of the common heritage of humankind is, and how that works into the current legal framework we're in.
Great. Look, it's a great question. And if someone were looking for a PhD topic, I would say, those 4 words would be a great place to start. I've got a PhD student who's presently working on a sort of parallel issue to do with the legality of space mining. And the common heritage of mankind is also a term used in some of the treaties, the Moon Agreement and the Outer Space Treaty dealing with space. And his conclusion was that while the same language was used in different legal environments, there was no underlying consensus that it meant the same thing in each, in that to implement the common heritage of mankind in the deep seabed meant creating, and it actually exists. You can go to Jamaica and visit its offices, the International Seabed Authority. Despite the fact there's no seabed mining and hasn't been in the 30-something years that UNCLOS has been running, there is a regulator there to do that job. But no such body, there is no outer space mining authority, right? So it was left as an undefined concept. So I mentioned the legal theorist Philip Allott before, and he had this sort of bon mot or saying that a treaty, so as national lawyers, we would often say jokingly, a contract is a disagreement reduced to writing, right? You get the 2 parties to a deal to work out what they can agree, and you put that down. And all the bits where they can't really agree, you find sort of language to paper that over. And you hope the business transaction goes ahead and no one ever has to look at the contract. But then if the contract arrives in court, you wind up having this debate about these ambiguous terms that were there to cover up the fact that the only thing the parties could agree on was language. So similarly, Philip Allott always used to say that a treaty was a disagreement reduced to writing. So you have all, particularly in something as complex as UNCLOS, where you had 140 negotiating states with very different views. Very often what you would agree on was simply a form of words. And sometimes you can agree on something that's very specific, like what is the width of the territorial sea? At the end of the day, that's got to be a number, right? So you'll agree that number, 12 nautical miles, fine. What is the status of the seabed beyond national jurisdiction? Well, in terms of the discussion I was having with Chris before, one of the ways you might try and have that discussion is to try and agree amongst yourselves, first off, what is the ordering principle that you'll organize yourself around? And who's going to disagree with the phrase, it's the common heritage of mankind? That's a wonderful statement that could mean any number of things subsequently, right? So one of the difficulties with the common heritage of mankind is it represents one of these wonderful legal concepts where we can agree, going back to Chris's earlier question about, is the law made or discovered? We can agree that this is the principle. But to work out what it means in practice, we would need more detailed rules, which could take a variety of forms. And more than that, it turns out it could take a variety of forms in different domains. So treating the deep seabed as the common heritage of mankind, treating outer space as the common heritage of mankind, treating the moon as the common heritage of mankind, treating potentially Antarctica. I can't recall if it's described as the common heritage of mankind. I don't think so, but it would be that sort of domain. But, we could have these different domains, but then working out what it means in relation to each domain might be a different exercise. I think that's a very long-winded way of saying I don't have an answer.
It's very eloquent, not an answer. Stephanie, do you want to follow up with anything?
No, I just wanted to say thank you. Yeah, that's really interesting. And I look forward to thinking more about that. Thank you.
But again, the thing is, one of the things the law does, though, is it leaves these resources around for future argument. So you can later come back to something and say, this cannot be devoid of meaning, right? Even if it was just agreed as a high-level principle at the time. So one of the things that, and I alluded to this in my talk, but sort of cut it in the interest of time, is that a grouping of small island states, the Council of Small Island States on Climate Change, decided as a deliberate tactic to pressure the meeting of state party, the meetings of state parties under the climate change treaties, the COP meetings. They got sick of those meetings being conducted on what they perceived as a business as usual basis. Like, we would like to make further cuts to emissions, but we can't because it would hurt our industries. You know, like the only concerns were economics or politics. So what they did was they spotted a legal avenue where an international organization could ask the International Tribunal for the Law of the Sea, established under UNCLOS, for an advisory opinion, non-binding but authoritative, on questions of the law of the sea. So they simply asked, in essence, what are the obligations of state parties to UNCLOS, the most widely ratified treaty in existence outside probably the UN Charter and the Convention on the Rights of the Child, like more ratified even than the World Trade Organization, right? So they go and say, what are the obligations of state parties in relation to climate change under the UN Convention on the Law of the Sea? And the tribunal ruled unambiguously that heat put into the oceans as a result of carbon emissions is a form of pollution under Article 1 of the Convention, and therefore states have a duty to take all measures necessary to prevent the further pollution of the oceans. Not all, I simplify, but it was still it still was put much more bluntly than many commentators expected. There is a legal obligation under the UN Convention on the Law of the Sea in relation to the protection and preservation of the marine environment to take immediately those actions necessary to stop the further impacts on the ocean of global warming. So that's an example of, as it were, rediscovering mechanisms and resources within the UN Convention on the Law of the Sea, which weren't necessarily anticipated at the time of its drafting. That doesn't make them legally invalid, but one of the things law, the gift of law is, at its best, it gives us a degree of stability. It provides a framework, but it also provides a framework within which change can be negotiated. And also in the international arena, it arms particularly states with little other material or intrinsic power, further symbolic and legitimating resources that they can take into political negotiations and say, no, this isn't a discussion about what's convenient or feasible or economically viable. This should now be a discussion about what is legally required. Now, at one level, that's merely a moral argument, right? But when you have limited other material or rhetorical resources, everything counts.
Thank you very much. I have a little list of questions that I won't be able to get through. I wonder if I might ask two of them together, and then you can choose whether you just want to focus on one or whether you want to do both very briefly. The first is to do with the incredibly important point that you raised towards the end of the talk, which is the ways in which alternative imaginaries of law and of the oceans can help to sculpt and change the way that the commons is thought of. And I'm particularly thinking of indigenous rationalities and knowledge systems, given that many indigenous communities have, a huge and rich and complex history of relating to the oceans in various ways. And just very practically, the first of my two questions is there any track record at all of those rationalities being taken account of or used to help forge global oceanic governance frameworks? Yep. And if not, is there any prospect of anything concrete happening in that way anytime soon? And the second question is, we tend to think, I tend to think, perhaps others do too, of the land as the center of our existence and the oceans as something somewhat peripheral to, to human existence. But I wonder what would happen if we flipped that and thought of what can the way in which we think about the oceans, and particularly the oceans as commons, teach us about the way we think about land? Is there any way that it can provide a model for reframing or refreshing the way that we think about non-oceanic environments?
Yep. I'll take the second question first and might manage to answer part of the first question in passing. So, for example, anyone who's interested might kind of Google the work of Beck Strating at La Trobe on this point. There is increasingly a sort of reconceptualization of ocean space. So a lot of small island states in the Pacific have started reframing themselves as big ocean countries that are part of a single blue continent. And this is a result of the legal artifact, the exclusive economic zone, right? The exclusive economic zone exists only as an artifact of law. There is no natural boundary that occurs at 200 nautical miles from each piece of land. But the consequence is, if you're a state made up of a scattering of islands through the Pacific, you might have very limited land territory that generates vast maritime zones going 200 nautical miles in every direction, potentially overlapping or meeting the zones of other Pacific island states. And if you add all of those zones up, you get the blue continent. And in some ways, that is a powerful reframing of small and disadvantaged states as actually having a greater significance that should be taken into account in ocean affairs. All of which sounds terrifically positive. But at the same time, a lot of continental states are, the phrase is creeping jurisdiction, asserting rights in the exclusive economic zone that the Law of the Sea Convention doesn't unequivocally acknowledge. So we've seen a lot of incidents between the United States and China and Australia and China where military or reconnaissance aircraft have transited through the Chinese exclusive economic zone. Now, on a conventional Western reading of the UN Convention on the Law of the Sea, putting a military aircraft through an exclusive economic zone is just an exercise of freedom of navigation, even if that aircraft is deliberately and designed only to collect intelligence about the mainland it is passing. That is still a legitimate use of the freedom of the high seas. The Chinese view is that a coastal state should be entitled to certain security interests in its exclusive economic zone. The phrase security interests does not appear in the UN Convention on the Law of the Sea. But if, for example, there was an overwhelming international consensus that such rights existed, then we would have to acknowledge that it was a part of the law of the EEZ. What I'm saying at the moment is it's a norm contest, right? Western states say, on a strict textual reading of the Law of the Sea Convention, show us where it says you have security rights in the EEZ that entitle you to flash blinding lasers at our patrol aircraft, drop chaff in their path, whatever. And China, for its part, says, well, clearly coastal states can be impinged upon by hostile marine activities off their shore. We have acknowledged sovereign rights and some degree of jurisdiction in the EEZ. Surely that should extend to security matters. As a positivist, I would say the textual approach does not favor the Chinese argument, but if enough states ultimately came to agree with China, it might have a point. So what I'm sort of saying is, these evolving questions of to what extent do we treat maritime space like land can be problematic if we just say we're going to apply the logic of territory to the ocean. And this brings us to maybe indigenous ways of understanding that might be more sophisticated rather than just saying, the sea is, to use again a Chinese metaphor, blue soil. Having a different conception of that relationship with space And again, going back to your point, maybe one more based on stewardship. So as I understand it, for example, in the cultural practices of Tuvalu, a newborn's umbilical cord may be cut in two pieces and one piece buried at land and potentially the other piece put in the sea to symbolize the fact that everyone born to Tuvalu has duties of stewardship to both the land and the sea, and they are permanently and intrinsically connected to it. But such a conception is different from the just treating land as territory. So I guess what I'm saying is, it's a mixed bag, and there are risks taking certain territorial approaches and embedding them in the maritime.
No, absolutely. That's really, really helpful. Thank you. I think Stephanie has a follow-up question, and I think we'll also make this the last question if we could.
Thank you so much. I just actually I keep thinking about this really interesting concept, and I'm sorry if this is an uninformed question. I'm not very aware about the legal status of non-human actors, but I was just wondering, is there any current discussion about the oceans as a common heritage of marine kind, or to whom do this idea of the commons apply?
So that's a really great question. And look, I am less familiar than I should be with post-human approaches to the law of the sea. I would say at the moment, though, there hasn't been a lot of centering of marine life and, what we might consider as humans, highly intelligent or sentient marine life as actors. So obviously, for example, the status of whaling as a legal activity has been contentious for a number of decades. And one of the problems with law, I've talked about it previously as a gift of stability. Sometimes, there's a sort of burden of ossification, right? Like the International Whaling Commission was a legal body that was set up on the basis that, whaling was one of the more important economic activities in the early industrial revolution. Whales weren't seen as a sentient species worthy of any kind of dignity or respect. They were just a resource to be extracted. So trying to use the International Whaling Commission as a body to create a moratorium on whaling was always a very awkward fix, and was very open to the Japanese objection. One, we know what severe protein deprivation in World War II looked like, and we would like to retain access to sources of marine protein, including whales. Two, we don't like being told what to do. And three, this body was never set up for this purpose, right? So what I would say is we've seen in a terrestrial context more movement towards centering non-human actors, such as giving legal status, say, in certain national systems. Again, I'm more ignorant of this than I should be, but to particular protected rivers or forests. So again, it requires a human agent to come to court on behalf of the river or the forest and say its interests are being harmed in a way that is legally protected. But at least the law acknowledges that it has a subjectivity. It's not merely an object of exploitation or extraction or human use or control. We haven't got there, bluntly, we haven't got there with the law of the sea. But something like the BBNJ agreement that expressly acknowledges, even if more as an aspiration than in implementation, stewardship, I think is important. But again, it's a negotiated document amongst a large number of states. So you still have to balance this tension for, well, there might be things that are medically useful in marine biogenetic resources. How are we going to balance human interests against the interests of the environment? But I guess at least what we are seeing is a greater recognition that for whatever ecosystems there are on the deep seabed, there's really no model of mining that wouldn't be environmentally disastrous. Right? At the same time, it's really hard to disestablish a piece of international law. I once asked a sort of chat group of colleagues, other than the League of Nations, can we think of an international organization that was deliberately and voluntarily dissolved? And the only thing that anyone could come up with was the International Tin Council, which was meant to be like a 1970s trading monopoly that bought tin from tin exporting countries and, you know, would have a backlog of it and would manage kind of the market flows to stabilize tin prices, which went about as well as you'd expect in an open market trading system. But, you know, it's really, really hard once you've set something up like the International Seabed Authority to stop it. That doesn't actually mean that any mining will necessarily occur, but we might wind up in a world where there is never any seabed mining, but there is still an International Seabed Authority.
Well, in a moment, I'm going to thank Professor Guilfoyle for tonight's seminar, but I just want to underline something before I do so, that I think this has just been a wonderful example of how to communicate across disciplines, how to open up the internal workings of one way of thinking to people who are unfamiliar with that particular way of thinking. Which is to say that I sincerely and deeply want to thank you, Doug, for all the effort that you put into making these ideas accessible to us non-lawyers. I think it's been a very rich time for us, and you've given us a great deal to think about. So please, everyone, would you join with me in thanking our speaker for this session, Professor Douglas Guilfoyle.
Thank you, everyone. It's been a great pleasure to speak to those who've been here this evening, and I hope others will catch the recording as well.